Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of constitution, that too in relation to matters involving constitutional validity of the amendment to section 2E and insertion of section 13A to the Payment of Gratuity Act. To know more about the summary of the Teachers Gratuity Benefits Case, please watch this video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button.
Hi everyone, today I'll be discussing a latest Supreme Court judgment with you all. So in the important judgment titled Independent Schools Federation of India versus Union of India and others, which was pronounced on 29th of August 2022, the Supreme Court has upheld the amendment of Payment of Gratuity Act 1972 extending the benefit of gratuity to teachers. The facts of the case would be that in exercise of powers conferred by Clause C to Section 1 Clause 3 of Payment of Gratuity Act, the provisions of the Act were made applicable to the local bodies in which 10 or more persons are employed as a class of establishments. So as a result, the schools under the local bodies with 10 or more employees became liable to pay gratuity to their employees. However, the notification did not apply to private schools. By another notification, the provisions of the Act were made applicable to the educational institutions with 10 or more employees. The private schools, being educational institutions in which 10 or more persons are employed, became liable to pay gratuity to their employees as per the provisions of the Act. Later, based on the recommendations of the Standing Committee, Section 2 Clause E was amended with retrospective effect from 3rd April 1997. Further, Section 13A was also inserted with effect from 3rd April 1997. However, several private schools challenged the constitutional validity of the amendments in writ petitions, and the same were dismissed by 7 high courts. These appeals, by the way, of special leave impugned those disputed judgments. Some private schools also filed writ petition under Article 32 of the Constitution, alleging that the Amendment Act 2009 overrules the judicial decision of Ahmedabad Private Primary Teachers Association versus Administrative Officers and Others, which was reported in 2004, and violates the doctrine of separation of powers, and the retrospective amendments are unreasonable, excessive and harsh, and therefore unconstitutional. The Supreme Court has held that the first ground should not hold this court for long, as the legislation in question rectifies the infirmities and defects pointed out by the court, and the amended Clause E to Section 2 defining the word employee and the newly inserted Section 13A with retrospective effect from 3rd April 1997 effectuate and catalyze the object and purpose of notification in question. This power to legislate with retrospective effect, which vests in every sovereign legislature, is not taken away by court's decision. However, a court's decision cannot be overruled by the legislature. The legislature can amend the language of the provisions that was the subject matter of the court decision, and such an amendment does not overrule the court's decision. Where the law, as in the present case, was amended and the defects were removed or cured, the law changes, and therefore the earlier interpretation is no longer applicable and becomes irrelevant, which enacts the laws, and the courts which interpret the laws as enacted. Doctrine of separation of power demarcates the exclusive domains of the legislature, which enacts the laws, and the courts which interpret the law as enacted. The earlier decision in Ahmedabad Private Primary Teachers Association's case interpreted the law, that is, Section 2 Clause E as it then existed in the statute. The judgment even acknowledged and prompted the legislature to enact a legislation granting the benefit of gratuity to teachers who were excluded because of the legal flaw. When the legislature acts within its power to usher in a valid law and rectify the legal error, even after a court ruling, the legislature exercises its constitutional power to enact the law and does not overrule an earlier court's decision. The second ground is again devoid of any merit and substance. The legislature, via the Amendment Act 2009, gave retrospective effect to the amendment provision of Section 2 Clause E and the newly inserted Section 13A with effect from 3rd April 1997, which is also the date of the notification issued by the government, making the Act applicable to the educational institutions. The amendment enforces and gives effect to what was intended by the notification but could not be achieved on account of technical and legal defects. The lacuna, distortion in the language that had the unwitting effect of leaving out teachers was rectified so as to achieve the object and purpose behind the issuance of the notification, making the Act applicable to all the other educational institutions. The argument of the educational institutions that they were taken by surprise is incorrect and unacceptable, as the legislation cured the inadvertent defect in the statute through legislative repair. Private schools, when they claim a vested right arising from the reason of defect, should not succeed for acceptance would be at the expense of teachers who were denied and deprived of the intended benefit. Marginal inconvenience in the form of financial outgo or difficulty is of little weight. When curing of an inadvertent defect is made retrospectively in general public interest, which consideration will overrule the interest of one or some institutions. This court finds little merit in this argument also for the reason that the observation of the court in Ahmedabad Private Primary Teachers Association's case was sufficient to indicate that a legislation should intervene to grant the benefit of gratuity to teachers. The contention that the private schools were sure to succeed as to deny the teachers the benefit of the notification in question is questionable and far-fetched to be accepted. The challenge was contested and remained pending before the High Courts and then this court. The private schools relied on some judgments of this court, but these judgments interpreted the word employee under other enactments. The law is subject to uncertainty ex ante when two or more views are possible, but there may be certainty ex post litigation in view of the law of precedence, which reduces uncertainty. Also, the argument of unreasonableness and that the amendment is financially confiscatory predicated on past liability, which may predate the notification effected from 3rd April 1997, is to be rejected as there are upper cap limit on payment of gratuity. Therefore, though gratuity is computed with reference for years of service in view of the upper cap limit, the payment towards gratuity cannot exceed the specific amount, even if the employee would be entitled to higher amount in view of the years of service rendered to the employer. The provisions of the Act, even post the retrospective amendments, will apply only to those teachers who were in the service as on 3rd April 1997 and at the time of termination rendered service of not less than 5 years. The period of 5 years may be partly before 3rd April 1997, as the date on which the person was employed does not determine the applicability of the Act. The date of termination of service in the form of superannuation, retirement or resignation or death or disablement due to accident or disease should be post the enforcement date, which in the present case is 3rd April 1997. The entire length of service, including the service period prior to 3rd April 1997, is to be counted for the purpose of computing the entitlement condition for 5 years of service. Further, the schools claimed violation of Article 14 and 19(1)(g), 21 and 300A of the Constitution of India, which are not violated, as to deny gratuity benefits to teachers upon enforcement of the notification in question was itself anomaly which mandated correction. A supplementary submission of the private schools was that the judgments of the court upholding retrospective amendments are valid only when there is a tax implication, as the government has also refunded the paid taxes, is unfounded and irrational. The power to amend, which includes the power to amend the statute with retrospective effect, is a constitutional power vested with the legislature, which is not confined and restricted to any particular type of statutes, namely tax statutes. So in case the constitutional validity of the Amendment Act is challenged, the court is entitled to examine the relevant circumstances which prompted the legislature to make retrospective amendment. Judicial review when a validity of an Amendment Act is challenged as decided on the grounds of lack of legislative competence, violation of the fundamental rights, or any other provisions of the Constitution of India. So in the present case, the notification in question ensured that the benevolent provisions requiring the payment of gratuity should be extended to the employees of the educational institutions. The amendment with retrospective effect is to make the benevolent provisions equally applicable to teachers. The amendment seeks to bring equality and give fair treatment to the teachers. It can be hardly be categorized as an arbitrary and high-handed exercise. The last contention raised by the private schools and writ petitioners is predicated on the enactment of the Repealing and Amending Act 2016, by virtue of which the Amendment Act 2009 was repealed. The argument overlooks Section A of the General Clauses Act 1897 and Section 4 of the Repealing and Amendment Act. Section 4 of the Repealing and Amendment Act states that the repeal shall not affect any of the enactment in which the repealed enactment was applied, incorporated, and referred to. It also states that the repealing act shall not affect validity, invalidity, effect, or consequences of anything already done or suffered, or any right, title, obligation, or liability already acquired, accrued, or accrued, etc. Therefore, the private schools would make the payment to the employees or teachers along with the interest in accordance with the provisions of the Act within a period of 6 weeks from today, and today as in that day when the judgment was pronounced. And in case of default, the employees or the teachers may move to the appropriate forum to enforce payment in accordance with the provisions of the Act. So that's it for today. Just in case of any confusion or any question, you guys can comment down this video. Thank you.